Welcome to the Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. As we always say, we provide information and resources that'll help you determine whether you need or want to contact a lawyer. Perhaps will help you decide that you can handle some issues yourself. If you do need professional counsel, you'll be better prepared, and as a result, so will the professional you select. Either way, our intention for you is to save time, save money, and of course, hopefully achieve the best possible results. The Bazar and Associates Law Firm in East Providence continues to donate their time, their experience, their insights on all of the issues that we tackle. And once again, we want to welcome and thank Attorney David Bazar. So today, we've talked about elder care and elder abuse. It comes in the form of physical harm, sometimes emotional abuse, but today we're going to be talking primarily about some of the financial abuse. It's hard to imagine, but every year millions of seniors are conned out of their savings, they're scammed out of their homes, and we know that it's been done through the internet and mail and phone, but many times it's done close to home. Done personally, close to home by one's own family member. So we have a few such cases to discuss today, the deeds and the dollars, particularly the property deeds that we'll go through. So David, this is a terrible thing. You have some cases, I have a couple to talk about, but just set the record straight for a minute so that we understand what we're talking about here. Sometimes kids, and even the adult kids, can be nasty, selfish, even unethical. At what point does it become something that is illegal and worthy of
a phone call to the authorities? So it depends on the situation. Oftentimes, a lot of estate planning is done as people get older. That does involve potentially giving away some assets, including the house, and various types of deeds to do that. And we've talked about that in the past, where there's an appropriate use of some of those techniques to help prepare the older person as they're looking down the line to possibly having a Medicaid situation and an application for that, and what you can and cannot do. And we've talked about how the state and the federal government and different entities have made it more and more difficult for someone to qualify themselves for Medicaid. But what we also look at as we're doing that is sometimes when these things are used inappropriately and not for the benefit of the person who we're trying to protect and allow to qualify for Medicaid, but for other purposes. And it's been interesting recently, we've seen more and more cases where people have been coming in after the fact with situations that arise that we actually always talk to our clients about before they do these things to warn them about some of the potential problems with the things that they're doing. So one of the more interesting cases that I've seen recently is an older woman who many years ago deeded her home to her daughter. And it wasn't even done with the life estate reserved to the mom. So when she deeds the home to her daughter, she actually deeds the entire ownership of that property to her daughter. Oftentimes, when we're doing estate plans so that you might avoid probate or help with Medicaid planning and that type of thing, you'll deed something that you own, that you live in, to your children or child, and reserve a life estate, which means while you're alive, you own it, and therefore nobody can put you out of the home. There's protections that you have with home ownership and all of those things. But if you do go into a nursing home and you had deeded this out, and usually at this point in time, the look-back period in Rhode Island, Mass, you know, if you're beyond that period, which 5 years in most cases, you're okay, and in Rhode Island, the home won't disqualify you anyway. And you've also protected it so that when you die, the person who would inherit it gets a step up in basis. When the woman deeded the house out, she didn't have any of those protections. And she didn't, and her daughter doesn't get the step up in basis. So a few years after she did this, an attorney contacted or tried to contact the daughter for her. It was ignored. And he was trying simply at that point in time to say, deed it back to your mom and let her deed it out to you with the reserved life estate so that you have some benefits from this too. No response. So then years go by and someone else has come into her life and she wants to protect him and make sure he has a place to live because they got married if something happened to her. So again, she tries to contact the daughter. Again, no response. And all of this time, she's been collecting the rents from the apartments and paying all the expenses of the property, the mortgage, taxes, insurance, although there's no mortgage at this point in time, and repairs. And so she's been using it as exclusively her property, and the daughter, who has nothing to do with either her or the property for more than 10 years and won't respond to anything, theoretically owns the property. The house was deeded to her years ago. So what can she do? So right now, all she can do is bring a legal action against her daughter. And we've warned people, even with life estates, when you do this, you lose control. And we can talk about ladybird language in a moment, but just the general life estate reserved deeding the remainder to your child or children ties up your property, so you no longer have control over it. So in some of these cases before, we've brought actions in Superior Court to either impose a constructive trust saying it's really this woman's property and you're holding it for her and you have to do what she wants as the fiduciary, being responsible for the property, or voiding the deed and having the property deeded back to her. Or in this case, and it's sort of an interesting angle that we're looking at, is since she's been using it to the exclusion of her daughter with no real permission from her daughter to use it because her daughter doesn't talk to her, we're going to file adverse possession and say that in Rhode Island, if you use a property exclusively as your property with all of the notorious outward appearance that you own the property and it's continuous and exclusive for more than 10 years, you can claim ownership of that property under the statute. So if we can't get the court to say that the deed was fraudulently obtained or should be void, maybe we can get the court to say that the property is actually ours because for the last 12, really more years, since it's been deeded to the daughter, we have done everything to control and maintain and use the property to her exclusion in an adverse way, so that adverse possession would apply.
So does this woman want her daughter to have the house upon her passing? She hasn't spoken to her daughter in 12 years.
Yeah, I'm not so sure that she does.
Okay.
However,
would that matter?
Well, it matters, and of course, if her daughter would be in touch with her, in contact with her, I'm sure what she would eventually say is, yes, I want to be able to use the house for myself. I want my husband to be able to use the house while he's alive. And then when something happens to him, I want it to go back to her. So I think eventually that's what she would want if the daughter would even have contact with her.
So it sounds like it's a peculiar story. You don't really have a sense in this case that the daughter is doing anything malicious, just that she's out of touch and it's created a very awkward and ridiculous situation.
Yeah, and so again, that's sort of what we talk to our clients as they're doing what you might call estate planning or in later life elder care, elder law planning, as to what some of the pitfalls you have to watch out for. Now again, in that particular case, the daughter, as I understand the story, is the one who took her mom to the lawyer and said, let's do this deed to, quote unquote, protect the house, which is what they'll often tell somebody who's getting older and worried about things. So the mom goes there without knowing that she's transferring all of her property away and without understanding exactly what it is that she's doing to protect the house, and signs this paperwork anyway. So is there, as you said, is it underhanded or anything? It maybe not to the extent where somebody is going to call in some of the other stories you have to talk about where people actually trying to steal something from somebody, but it's not exactly above board in being done in the appropriate way either in that case.
So you wouldn't really call that or put that under the banner of, what do they call it, elder abuse, civil litigation. It's not necessarily that, it's just a different story when you're talking about adverse possession. In too many of these stories, and one that I know personally, but in too many of these stories, there's absolute outright intent of fraud. And in that case, that's not a matter of selfishness or
Right.
whatever. It's really a matter of someone with the intent to do evil. I mean, honestly, if it's a child who's cashing a check, forging a check, outright stealing property, coercing someone into signing a deed or a will, and then they realize that their child is doing them, and those kinds of things could be under the banner of fraud, could they not?
Sure, and there's a lot of shades of gray, I would say, in between out and outright fraud, which might be a non-relative even calling up and saying, you know, go and get me that prepaid card so that, you know, I can get your relative home from England or whatever. And I know you have some stories like that. And the case where we're trying to do some legitimate estate planning, and the child at that point really might not have had anything to do with the parents' decision to add them with the remainder interest, but now won't release that interest because the parent wants to sell the house and move to Florida. So in between those two places on the scale are lots of areas of gray that might come to the point of, is that fraud, is it not fraud? It's certainly not right. And you know, there are instances where there's a relative who's trying to help an elderly or older relative out with some finance stuff. I mean, put me on your bank account and I'll help you write checks. Put me on your investment account and I'll help you make trades. And so it starts out with the right intent, perhaps, and they were added on what I would call for convenience only. And now the person who's getting older is either infirm or dies, and all of a sudden that person who was really just helping thinks, well, that's my money and I'm going to take that money. And that isn't right either. That may violate the intent of what that person wanted to do. They might have a will that says joint accounts are not intended to be joint accounts. You know they're not joint accounts. You can't take my money. It's to be divided up amongst the people in the will as I name them. Thank you for your help. Maybe I named you in my will for helping me, but don't take my money. Help me, yes, don't take my money. And so that has gone from really what was a nice, helpful, good situation to something where you're either defrauding the person while they're dead or alive.
And when you happen to be, say, the friend or even a family member, and you suspect that there is something going on, how actually do you think someone could be helpful to that elderly person to intercept a problem before it becomes a very serious problem? I mean, I think that it certainly makes sense that if you are the child and you're a good child, you are watching, talking to your parents and making sure that everything stays the same. But the minute things start to change, they get more forgetful, and you want to tune in. Let me look at the bank account, the insurance, the deed, or who you're talking to, or what's going on online. You start to see something that looks strange. How involved do you get, and without causing trouble? Are you likely to be able to say, Mom, let me check that insurance policy?
Yeah, and I think the best thing a family member can do, the best thing that a family can do, is try to tackle these issues while everybody is competent and knows what they're doing, and let's just put it on the table and be upfront with each other, mother, father, children, all children, and make sure everybody's on the same page and understands what we're trying to do. Even if there might be a little bit of pain now in telling one or the other children that, well, we're going to do this and here's why we're doing it, and it might not be what you want, but this is what we're doing. I think by doing that all in advance may save a lot of problems down the road. And then what goes hand in hand with that is to have very good, precise estate planning done so that you accomplish what you want to do without putting one of your children in a position where they may end up doing something you don't want them to do. And so here's what I mean by that. You're talking about somebody who's added to a bank account to help write checks, all right? Very careful when you add them to the bank account that they're added to write checks only and not with right of survivorship, because you have 3 other children and you want that to be divided equally. So one way to do it might be, if the bank will let you do this, is to give them power of attorney to write checks. not add them to the bank account to do that. File the power of attorney with the bank so the bank knows that you have authority to write the checks, but let's not confuse the situation by actually putting your name on the account individually with right of survivorship, which was never intended in the first place. So talk all these things through with all the family members and with the attorney who's going to draft the documents, get good advice, and then do it in such a way that whatever it is that's your intent is most likely best able to be carried out the way you want it to be done.
And actually, you've provided a perfect segue about another scenario here, and it's specifically about the powers of attorney. And in this case, a son's unbelievable use or abuse of it. And the short version is that there's an 80-year-old dad who's a Korean War vet. He gets disability. He has purchased houses. He owns his car. Everything's free and clear. He has about $300,000 in the bank. And understandably, over time, his mental capacity begins to diminish. Meanwhile, a son who's somewhat of a ne'er-do-well sees an opportunity to strike, and he does. The long story short, he first has his dad sign over the power of attorney for financial and health care decision-making. We've discussed this before. But within that situation, he ends up drawing all the monies from the dad's disability, VA disability money. He transfers all the titles of the properties, I think there were 4 or 5 of them, into his own name. He ends up selling one of the properties and gets the proceeds. You understand where this is going. And I think he sold it less than what the market value was, but the point was this is clearly not a good thing to do. He eventually puts the father in the nursing home, lists information that says no one gets to see this man without my say-so. So here he's running his own little fiefdom, and he's doing a terrible job of taking care of dad. So now, who, what, when, where, and how do you intervene? The power of attorney is supposed to be a very good designation. As the father becomes more feeble, less likely to exert his own rights, protest, how do you intercept, how do you intervene and change that problem of power of attorney? And I understand there's a word called conservatorship coming in. What do you do, David?
So what you're describing is a situation where the father tried to do the right thing with his estate planning, and he picked somebody to help him do that, the son, and the son has now breached his fiduciary responsibilities back to the dad by abusing the rights that were given to him in the power of attorney and not using them for the father's benefit. So a guardianship or conservatorship could be filed with the probate court in the town or city where the dad lives. Who
would do that now, David?
Well, that's the question. Are there other children?
Apparently not. And in this case, it was just this son decides to swoop in and goes after the father. I'm not sure that his intention was initially good, that the father thought this was a swell idea, but he cons his father into doing because he's starting to become enfeebled. So who gets to intercept that? How does that happen? If I'm a friend, can I go call David as an attorney? What happens?
Well, as a friend, you can call David as an attorney. You can call the elderly abuse hotline, and there are numbers for that, and I think you have those.
We're going to give them in a minute.
And there are advocates in the state of Rhode Island that help people who are in nursing homes make sure that their care is correct, but I think you could also contact them and they can point you in the right direction. Long-term care, something or other office. I think it's a division of the state of Rhode Island. But there are absolutely places you can go, and hopefully somebody who sees what's going on in this man's life, the father, is concerned enough that they bring somebody in who can dig in and look at what's going on. Now, in that particular instance, if the will would have left everything to the son, and that was the father's intent anyway, you wonder what you need to do about it. Certainly money has to be protected at either conservatorship, guardianship, or whatever, for the dad to make sure he's got enough money to live the rest of his life on. But if what this person is doing is really just pre-spending his inheritance, but there's still enough, I think it's really important, no matter what, to make sure that there's enough money to protect the dad. And so maybe somebody's got to step in, push that son aside, make sure that the dad's taken care of the way the dad needs to and should be taken care of, And then whatever left, if the will leaves it to the son, then he gets it at that time.
Now, we've talked before about some things that people could do on their own, but if someone needs a power of attorney, that they need to go to a lawyer for that, and I understand that. If someone's talking to a lawyer, this son's going to a lawyer to start this process so that he has the POA, health and fiduciary, financial, wouldn't it make sense that a lawyer would say, I'm not sure that it makes sense that you should ban everyone from seeing your father in a nursing home unless they visit and get approval from you. Wouldn't that red flag so that that could never have happened in the first place? Or would that be a reasonable thing to pass through a lawyer's desk and have him rubber stamp?
You would think the nursing home would see that as a red flag. So we talked about, can you draft these documents on your own? And of course the answer is many times you can, but the value of the lawyer isn't the drafting of the documents in and of itself. It's the discussion and the digging in on all of the issues that surround your family and your finances, and making sure that you're taking the right steps and protecting things that you may or may not think of. So in a situation where you had that son who was taking advantage of the father, what a lawyer would want to ask that father is, are there other people you trust that you would want to have oversight over this? So if the father had concerns about the son's ability to take care of money, to make decisions, the son might not have been the best choice to be the power of attorney. The son might not be the best choice to be the executor of the will, perhaps. The son might not be in the best position if there's a substantial amount of money to take care of the money even after he gets it. So the lawyer might want to talk to that person, the dad, to determine who should be the financial power of attorney. Should there be a will with the trust or a trust? Should someone else be the trustee to take care of the money for the son to protect the son from himself? So it's really all of those issues that get brought up and discussed and flushed out. That's the value of having an attorney weigh in with you as you decide these things. And
as far as those instruments that we've discussed in various segments previously, if it's a power of attorney or an estate, isn't there always a second in case the first dies, becomes ill, can't perform his duties? Isn't there always someone else who's in the second position to take over this, and that second in position should be the one to perhaps call the lawyer or call that first in position saying, I think you're not handling these things correctly, we better have a powwow, or we need to go to a lawyer or something? How does that generally play out, David?
You would hope that there is. But there are times where the person just doesn't have anyone or doesn't want to name anyone. So there's not that, but the point is the lawyer will talk that out with them. My recommendation is that you have a backup. My recommendation is that there be somebody else named on the healthcare power of attorney. My recommendation is that if there are certain things that you want spelled out, make sure those are spelled out. My recommendation is if that child is not good with money and not trustworthy and not responsible, find somebody else, name a professional, name somebody else who can do this job for you. So those are important things.
And if you've made a good choice at the outset and the situation changes, the son became a drug addict or was arrested and started to steal money, can you change these instruments? Not the deed necessarily, that's done,
right? That's the problem with the deed. Yeah, we talked a little bit about ladybird language. At one point in time, you could craft a deed that allowed you to claw back, so to speak, or take back, reserves the right to redeed and take those people off. Medicaid does not allow you to use that language anymore. So we don't use that for Medicaid planning, certainly, but those deeds can create their own problems.
And we don't have a lot of time left, but another situation where, not with a deed, but a granddaughter decides that she's going to cozy up to grandma again, although she's not been around very much. She manages to con grandma into letting her sign checks, and there goes the bank account. Unethical? Is it illegal?
It could be illegal if she were taking money that she knew wasn't hers and against her grandmother's wishes. it would be, there's robbery where you go in and you take the title to the property that doesn't belong to you at gunpoint or whatever, stealing. And then there's theft where you take title to something that you had the right to take the title to, but then you convert it, it's conversion to your own use, that's still stealing.
So people need to be aware of these things. I'm not sure that every viewer who sees that something might be awry, whether they can do the judgment call, but we have a couple of telephone numbers that I think that they can put up on the screen. If you suspect that there is some elder abuse, there are numbers that are available to be put up here to report elderly abuse. In Massachusetts, 800-922-2275. In Rhode Island, there is a number, 401-462-0555, and that's if there's home abuse. If you find there's a problem with a facility or a nursing home in Rhode Island, 401-785-3340. I think that these things certainly bring to people's attention that there is a place to go, as long as the elderly person, if they start to see something happen, they so often are ashamed, afraid, intimidated. Perhaps they're afraid that the son or that daughter, whoever is going to do them harm. They need to know that there are ways to reach out, whether they call this line or some phone number or even a friend.
Right. I think the last number you gave might have been for the Alliance for Better Long-Term Care or something.
The facilities, yes.
Yeah, so, that is important, and they can help with those other situations too. So if the facility isn't treating the patient, the resident well, they can help with that. But I've also seen them get involved where they sense that there's financial abuse or other family members interfering with the care of the patient. So those are good numbers to have.
When we talk about helping seniors not be targeted, apparently they know that seniors have a lot of time. They're more likely to surf the internet and very likely to hook up with the wrong websites that take advantage of them. Emails, phone calls, seniors have time. They're willing to talk to people. Unfortunately, that's when they often get misguided and connected incorrectly and need to have someone swoop in. If it's not about a deed, if it's about money, what do you do if you aren't the family member? You can't call that elderly person's bank and say, I think that there's some fraud going on. What do you do?
Well, maybe bring them to an attorney and let an attorney dig in on it for them. But certainly, an attorney can contact a bank on behalf of a person. I would bring the person you have the care and concern for to the attorney and let the attorney try to get the information for them.
What should you do if there is an imminent emergency where someone's being abused? Not necessarily with a deed, because that's not a life-threatening thing. It's certainly tragic, but someone is likely to sign off their firstborn and every cent that they have. Is one of those numbers likely to get a quick response, do you think?
I'm not sure.
Versus a lawyer?
Lawyer, and maybe a police department too. And maybe they can send in someone to look at the situation and see if there's a crime being committed.
I will say, in one personal situation that I can share in very few seconds left, that we did end up calling the state police and they immediately jumped in.
Yeah.
We hope that this has been helpful to you. We hope, of course, that you don't have any of these issues. I hope that those numbers have been helpful. Elderly abuse is something to be watchful of. Stay tuned and tune into what seniors you can help protect. Thank you for tuning into the Law Matters, because the law matters to you.